Thanks to everyone who have subscribed. If you have not, please do. And thanks for coming out here. I really appreciate you. How Ihedioha'S appeal splits Supreme Court. Well, here's an update on still going Ihedioha'S case. I want to give the details of what really happened, how the Supreme Court was split between decision. Let's go to the news. The tussle over who governs Imo State for another 4 years ended yesterday as the Supreme Court dismissed the appeal filed by the outbusted governor, Emeka Ihedioha, and his People Democratic Party, PDP. They had approached the Apex Court seeking a review of the judgment that removed Ihedioha from office, but 6 out of the 7 justices of the Apex Court, led by Chief Justice of Nigeria, CJN Tekwa Mohammed, dismissed the application on the grounds that the court could not reverse itself. In the judgment read by Justice Olukoyade, the court held that revisiting its January 14 verdict will open the floodgates of similar applications, he said. The application was an invitation for the Supreme Court to sit on appeal over its own final judgment. Granting the request of the applicant will open the floodgates of parties to all kinds of litigants. The general law is that the court has no power under any provision order to reverse any application unless to correct an error. This court has on each occasion stated that it lacked judgmentation to do that. We cannot sit as an apex court or appeal court. We have no hearing power in respect of this matter. The court does not have the compulsion and lacks the judiciary judgment to review its own judgment. The facilities of the Supreme Court is inherent in the Constitution. To ask us to set aside means an appeal for us to sit on our own decision, which we have on judiciary jurisdiction applied and declared. The application is hereby dismissed and parties are to bear their respective curses. But another member of the appeal, Justice Chima, in a disgusting tone, delivered an opposition judgment that attracted large cheers, an attraction that defiles the tradition of the court. In a very detailed judgment, he maintains that the Supreme Court had the inherent power to revisit its judgment and asked his colleagues to do so in the interest of justice. Describing the January 14 judgment that sacked Ihedioha as the wonder that should never end, the justice asked the court to exercise its inherent judgment and redeem its image. He also confronted his colleagues with an instance in the Nigerian Supreme Court and other courts, including those of the United Kingdom, United States, and Australia, where courts has exercised power over their rule by themselves, and consequently urged his colleague to visit the recent judgment in the interest of justice. The judge, however, added that except the judgment recently delivered was set aside, it would continue to haunt the National Electoral Judiciary Committee. Revisiting the Imo State judgment, Justice Nwoze pointed out that the candidate of the All Progressive Congress (APC), Hope Uzodinma, in his petition presented his case without the record of accredited voters. According to the justice, Uzodinma misled the court to accept the results of the election from his angle. He said there were over 129,340 votes in excess of accredited voters. The court can redeem its image by setting aside its judgment. If not, This will continue to hurt our electoral prejudice. It is awakened and it will be embarrassing to the court if he misled the court. When the applicant presented on the table of exhibition his mischief excused the votes of others, the court declared him winner. I am on the firm view that this court should set aside the initial judgment and restore the judgment of the lower court. Justice Nweze added that the Apex Court had a duty in the interest of justice to set aside his decision that was given in error. To him, the judgment that declares Ozedema winner was entered in error. Ihedioha had on February 5th approached the court for a review of the ruling that sacked him and returned Ozedema of the APC as the duly elected governor. As the resumed hearing yesterday, Council of Ihedioha and People Democratic Party Chief Canon San asked the court to set aside its earlier judgment and uphold the verdict of the lower court, which upheld the election of Ihedioha. He noted that an error was disclosed in the judgment as the total number of votes cast exceeded the accreditation by the total votes numbers of the states. He also asked the court to set aside the judgment to restore Ihedioha as the governor of Imo State. But counsel to Ozedema and his APC, San, asked the court to dismiss the application for review for lack of incompetence and merit. He argued that the Apex Court lacked jurisdiction to revisit its earlier judgment, adding that the verdict was clear without any ambiguity. We want the court to dismiss the application for incompetence and lack of merit. The thrust of this objection is that there is total lack of jurisdiction of the court to revisit its judgment of February the 14th, 2020. Irrespective of whether the application is characterized as an application of review or classified as an application to set aside or however dressed, this court is consequently and rightly so held that there is lack of jurisdiction to sit and revisit its own judgment. The only exception is if there was a split in the judgment rather does not reflect the intention of the court. But it is not is not so in this case. Therefore, the invitation to review is not tenable, he argued. According to Doldo, there is no ambiguity in the judgment. It is clear and categorically no one can invite this court to reconsider its appeal. The application is inconsequential because there is no judiciary judgment holding to that regard. Although Justice Nwe's pointed position was overridden by the majority judgment of the other 6 members of the appeal panel, it appeared to have provided the needed certain blame on losing sides of the division. In fact, the court lost the usual excitement and noise after often heard of victory of this sort. There were unusually quietness as people filed outside the court quietly. In its reaction, the PDP described yesterday's verdict of the Supreme Court as a disconnecting endorsement of electoral fraud, which places a huge burden on the courts and the judiciary system and justice system of the country. PDP, in a reaction to the judgment by its National Publicity Secretary Kola, noted, however, that in the face of the sad verdict, Justice Nwe's judgment presents a glimpse of hope for our national judiciary system. Our party abides completely by every word of the justice of the Supreme Court. We, however, appeal to the appeal courts to look inwardly and to say exactly if their verdict has been what it should be. Well, here is a snippet on. So, guys, I really want to hear your thoughts on what you think about the judiciary system of our country, because I think personally that this is Remember that the PDP is trying to reveal Buhari's presidential win. So I think it's a system to kind of discourage people or make them scared of reviewing anything that has gone through the court system. It's a way of making people be living in a denial, being be scared and afraid. So that's what I think. So leave me your thoughts. Don't forget to like, share, subscribe, click on the notification button so we can get all our latest news. Thanks for listening. God bless. Have a good day. Bye.